Good afternoon. I want to commence by acknowledging that I work on the land of the peoples of the Kulin Nation and pay my respects to their elders past and present and to their emerging leaders also. And on behalf of you all, to acknowledge the traditional custodians of the land on which you are sited, wherever that may be across Australia or indeed across the world. My name is Pip Nicholson and I'm the Dean of the Melbourne Law School, and it's an extraordinary pleasure to welcome you to this joint webinar between Melbourne Law School and the Australian Law Reform Commission to launch the Company and Securities Law Journal Special Issue, Financial Services Law, Understanding the Devil in the Detail. It is a cold and gloomy afternoon in Melbourne. I hope it's better than that wherever you're located, but it is wonderful to see so many people coming together to have what I hope and am very confident will be a fascinating panel discussion. Before I briefly introduce the speakers, a couple of matters of housekeeping. The chat function has been disabled, but you are very warmly encouraged to submit your questions through the Q&A function. So please do share your questions with us, but through the Q&A function rather than through the chat function. And the other preliminary comment is that these proceedings are being recorded, and the film or video footage will be available both through the MLS and ALRC websites shortly. Today, as I've said, we launch a special issue of the Companies and Securities Law Journal. And as mentioned, this is a collaborative project worked between the Australian Law Reform Commission, Melbourne Law School and legal academics from across the sector. This issue also, as most of you no doubt already know, also aligns with the ALRC's current inquiry into financial services legislation in Australia. And so the webinar's focus is to explore financial services law through the lens of the special issue of the journal, with a focus on the devil being in the detail. Let me move to the speakers now for today's event. First, you will hear from the Honourable Sarah Derrington, President of the Australian Law Reform Commission and Judge of the Federal Court of Australia. Justice Derrington will also chair the Q&A at the end of the panel discussion this afternoon. By way of background, so you feel you know Sarah, prior to her appointment to the Federal Court, Justice Derrington was the Dean of Law at the University of Queensland and a barrister specialising in maritime and shipping law, general commercial law and also in arbitration. After Justice Derrington, you will hear from Edmund Finane, editor of the Company and Securities Law Journal, who will introduce the Company and Securities Law Journal Special Edition, talking to you of the focus of this publication. Corporations law expert Associate Professor Rosemary Langford from my school, the Melbourne Law School, will then present her keynote comments. Finally, there'll be an opportunity to ask questions to a panel of speakers comprising Honorary Professor Andrew Godwin, formerly of the ALRC and also with the school, Cindy Davis from the ALRC, Associate Professor Scott Donald from UNSW Law School, Professor Gail Pearson from the University of Sydney Business School, and Phoebe Tapley from the ALRC, joined together with Samuel Walpole of Council. I would like to thank all of the speakers for sharing their time with us and their expertise with us, and very much look forward to the seminar. I will now hand across to Justice Derrington.
Thank you very much, Dean Nicholson, for those words of welcome. The ALRC is really pleased to continue our partnership with Melbourne Law School for this event, and we're extremely grateful for the Law School's continued support of the ALRC. After all, Research is the most important plank of our function, and being able to collaborate with world-leading academics is essential to our work. It gives me great pleasure today to launch this special issue of the Companies and Securities Law Journal. I would like to be doing it by breaking a bottle of champagne over the stem of the journal, but I've been told that's not allowed on Commonwealth property. But this is a close collaboration between leading legal scholars and the ALRC as part of our inquiry into the simplification of financial services and corporations legislation in Australia. And we are very pleased to have a number of the contributors to the special issue joining us for today's panel discussion. Now, this inquiry is part of the government's response to the Royal Commission into misconduct in banking, superannuation and the financial services industry. We are not, however, tasked with recommending policy changes regarding the content of obligations on financial service providers. Rather, this inquiry is more technical in nature and seeks to facilitate a more adaptive, efficient and navigable framework of legislation within the context of the existing policy settings, difficult though that task may be. So our ultimate goal is to achieve meaningful compliance with the substance and intent of the law. In the final report of the Financial Services Royal Commission, Commissioner Hayne observed that simplification so that the law's intent is met would require a detailed examination of how the existing law fits together and identification of the policies given effect by the law's various provisions. The ALRC has embarked upon this process by undertaking detailed mapping of the legislative framework and across all financial services legislation, not simply the Corporations Act. Observations and findings from some of the ALRC's preliminary mapping of licensing and financial product disclosure provisions provided the impetus for this issue of the Companies and Securities Law Journal. The ALRC's analysis of these preliminary findings has greatly benefited from the contributions of a number of leading academics to articles in this special issue, including our keynote speaker today, Associate Professor Rosemary Langford. Dean Nicholson has already introduced Rosemary as a member of the Melbourne Law School, where she teaches a broad range of subjects, including corporations law, principles of business law and corporate governance, and directors' duties. And we are indebted to Rosemary more widely. She has played an integral role in bringing together this special issue, as well as providing her contributions to the editorial and to 2 articles in the issue. Before we invite Rosemary to deliver her keynote address, I will hand over to Edmund Finane of Counsel, who is the General Editor of the Companies and Securities Law Journal, to introduce the special issue. Thank you, Edmund.
Thank you, Judge. My apologies in advance if I have some connection problems. I do have a backup plan, which hopefully I won't need to implement. On behalf of the Company and Securities Law Journal, I'd like to thank the Melbourne Law School and the Australian Law Reform Commission for hosting this event. And I would like also to welcome all of you in attendance today. I do wish that I could have come to Melbourne and attend in person. Not only is Melbourne a marvellous city, it's also the home of a number of people who have played an important role in the success of the Company and Securities Law Journal since it was started in 1982. Now, if I go back to that time, to the early 1980s, and think about the subject matter of the special issue of the journal that we're talking about today, the truth is that financial services were not the subject of much discussion at all in the early days of the journal, and not really until the late 1990s. Following the Wallace report in 1997, as well as a Treasury report shortly thereafter known as CLERP 6, the Australian Securities and Investments Commission was established, and part of its responsibility was to regulate what we now call the financial services industry. Then under the Financial Services Reform Act 2001, a new Chapter 7 was introduced into the Corporations Act dealing with financial services and markets. In this way, the regulation of the financial services industry became a company and securities law topic, just as much as the regulation of prospectuses and market disclosure and takeovers. Now in 2021, several scandals and inquiries and reforms later, this area of law has actually provided a fertile ground for writers of journal articles, and we've published quite a number of articles on financial services in the journal. In fact, we had another special issue on financial services in 2017, addressing consumer protection in financial services. Since that special issue, we have, of course, had the Royal Commission into Banking and Financial Services, and the recommendations of the final report included recommendations for the reform of financial services legislation, including simplifying the law and removing exceptions and qualifications. Now, Rosemary Langford told me last year that there was a project underway involving the Australian Law Reform Commission, as well as herself and other scholars in this field, looking at simplifying the financial services legislation. And she asked if the journal would be interested in publishing a special issue devoted to articles arising from it, subject, of course, to the usual peer review process. I was and am grateful to Rosemary, and indeed all of the other authors and the Australian Law Reform Commission, for bringing this content to the journal for publication. They really are interesting articles showing us where the legislation is at present in terms of complexity, and putting forward what seemed to me to be sensible proposals. I'm not going to go into the details, largely because of time constraints, and also because we have speakers from each of the 5 articles in the panel today. And of course, we've got our keynote speech from Rosemary Langford coming up. The papers in this special edition don't pretend to be the final word, but they will be a fine starting point for some important discussions that need to take place. Thank you again. And now I would like to hand over to Rosemary Langford.
Thank you. Well, it's a great pleasure to be part of today's webinar and share my thoughts on how the articles in this special issue of the Company and Securities Law Journal can contribute to the debate about reducing the complexity of corporations and financial services law and regulation in Australia. I'd like to comment very briefly on 4 topics. Firstly, the ALRC mapping exercise that led to the articles in the special issue. It's already been mentioned. The question of legislative design, the state of corporations law in Australia, and the interesting research that's being undertaken both at Melbourne Law School and elsewhere on related issues. First, it's really difficult to analyse legislative complexity and to come up with solutions as to how it might be reduced or simplified without an understanding as to how to measure complexity and without access to the necessary data to support that understanding. And the mapping exercise that the ALRC undertook last year was designed just to do just that, namely to measure and map complexity in 2 key areas of financial services regulation, disclosure and licensing, in order to provide a better understanding of complexity. Following that impressive exercise, the ALRC invited a team of academics to collaborate with them in producing 5 papers on related questions. What does complexity reveal about the regulatory landscape in Australia? What issues and challenges have arisen as a result of that complexity, and what might be done in order to reduce the complexity? With thanks to Edmund and his team, these papers have now been published as articles in the special issue of the Company and Securities Law Journal that's being launched today. The articles serve as a really useful starting point for a discussion about complexity as it relates to corporations and financial services regulation. The articles explore key questions raised by the mapping exercise across 5 areas: legislative design, legislative hierarchy, disclosure, licensing, and duties of loyalty. Let me say a few words about legislative design, as it's a theme that weaves its way through all 5 of the articles. So the research and analysis for the first article, which is on legislative design, reveal at least 3 interesting themes or propositions. First, detail in policy leads to detail in legislation. In other words, the more detailed the policy, the more likely it is that the legislation itself will be detailed. We might assume that greater detail leads to greater clarity and easier compliance. However, as we've seen in the area of corporations and financial services regulation, detail actually often leads to complexity and the need to recognise exceptions and qualifications. So what initially began as a principles-based approach can subsequently turn into a framework that's overladen with exceptions and safe harbours. And we can point to the framework governing the best interest duty of financial advisors as an example. In turn, a high level of detail can lead to a highly prescriptive tick-the-box approach, which ends up concealing the intent of the law and making it difficult to glean the underlying norms and policy settings. And that, of course, was the subject of at least 2 recommendations from the Hayne Royal Commission. It's ironic that detail, which is designed to implement policy and clarify the law, often leads to a situation where the intent of the law becomes clouded and difficult to discern. A second theme or proposition is that things tend to be cluttered over time. Many of us experience that in many areas of our lives, and corporations and financial services law is no exception. It's often so much easier to resolve uncertainties and plug gaps by adding further detail than to go back to the fundamentals and rationalise, streamline and simplify the law. And we know, of course, that the Corporations Act has been reformed many, many times over the years. Clutter manifests itself at each level of the legislative hierarchy, namely primary legislation, regulations and legislative instruments, and also in the overlap that exists between each level. And coexisting with all of this is the general law as reflected in case law and an increasing volume of soft law in the form of regulatory guidance and industry codes, which often have a binding effect as a matter of contract. I understand from Andrew Godwin that the design of the legislative hierarchy and the fundamental question of where the law should be located are key issues that the ALRC is examining in its inquiry, and these are indeed important issues. Thirdly, and again, I understand from Andrew that this reflects stakeholder feedback that the ALRC has received to date, it's necessary to achieve an appropriate balance between various styles of regulation. We know principles-based regulation, rules-based regulation, outcomes-focused regulation, and risk-based regulation all have their place in the design of the legislative universe. The critical question, of course, though, is how these forms of regulation should be blended to produce legislation that's both coherent and practical. And that all leads me on to the third topic I'd like to comment on briefly, which is the state of the corporations law. So as most of you would know, or all of you would know, the Corporations Act in Australia has been the subject of much criticism over the course of its 20-year life, which we're celebrating this year. It's also been the subject of a lot of humour. There are many perspectives from which we could give the Corporations Act a hard time. Justice Reries of the Federal Court of Australia, for example, has asked rhetorically, do we need a telephone book size statute to regulate corporations? And we know that the Corporations Act has expanded exponentially over the years. Bob Austin recently remarked that the 1936 New South Wales Companies Act was 263 pages, the 1961 Act was 415 pages, and the 2021 Corporations Act is 2,000 pages. Many others have waded into the debate, both in relation to the current Corporations Act and its predecessor, the Corporations Law, which Sir Anthony Mason described as indigestible and incomprehensible. Academics have described the Corporations Act, and I quote, as unlovely and unloved, obese, economically burdensome, inconsistent and conceptually troubled, and as a rider galloping off in all directions. I think it's important, though, to acknowledge that the Corporations Act and corporations law generally have served us well in many respects, such as, for example, regulation of takeovers and securities, and that it's not all bad news. Moreover, a complete rewrite or replacement of our Corporations Act, as was done by the UK in 2006, is, in my view, untenable. At the same time, rationalising and reconceptualising problematic areas of the Act is much needed. The key question is how the law might serve us more effectively and in a way that results in better outcomes from a compliance and enforcement perspective. Enforcement, of course, was a key issue that was discussed by the Hayne Royal Commission. On this point, I should note a change in my own views on one part of the Corporations Act, namely the statutory director's duties in Chapter 2D, I've previously described our dual system of directors' duties arising under general law and under statute as incoherent and chaotic, particularly due to the differences that exist between the general law and statutory duties in relation to conflicts and profits. More recently, I've come to the view that it may well actually be appropriate that the targeted provisions in sections 182 and 183 on improper use of position and information require a higher level or severity of conflict, given the potentially serious civil penalty consequences. Also, in research I've undertaken with Ian Ramsey recently, we've shown that there's actually not a great deal of difference between the concepts of conflicts of interest and material personal interest for the purposes of sections 191 and 195. The issue of ratification of breach of statutory duty, however, remains complex. Questions do also arise as to the fitness of the Corporations Act as society and its values change, particularly given legislative initiatives in other countries to specifically facilitate purpose-based companies. Although in recent scholarship, I've demonstrated that our Corporations Act does indeed allow purpose-based companies. The factors behind regulatory complexity are of course numerous and include the growing complexity of financial products and transactions, the increasing involvement of retail investors in the financial markets, and more generally, the impact of technology and the financialisation of economies around the world. Alongside these factors are of course advances in our understanding of financial regulation, and in particular, the relevance and limitations of concepts such as disclosure and financial literacy. We're also seeing an increased focus on the importance of financial well-being and the possibility of incorporating this into the regulatory landscape. Before closing, let me say a few words about what's happening in the area of research. And it has actually never been a better time to research corporations and financial services regulation. There are many interesting areas of corporations and financial services regulation in which researchers at Melbourne Law School and elsewhere are involved. Many of these, of course, relate to technological innovation. For example, researchers are looking at corporate governance in the context of new business forms that are supported by technologies such as blockchain technology. Researchers are also examining new forms of fundraising, such as peer-to-peer lending and crowdsourced equity financing, and new forms of financial advice, such as robo-advice. An essential dimension to all of this are the opportunities and challenges that technology and innovation present for directors and other stakeholders. An example is that a number of scholars from a number of jurisdictions around the world have recently collaborated in a book on technology and corporate law coming out in August, which I've co-edited together with Andrew Godwin, who's part of the panel today. More broadly, this special issue of the Company and Securities Law Journal and the ALRC's current inquiry tie in with a broader theme of my own research, namely coherence and clarity in governance and regulation frameworks, particularly in light of the importance of the rule of law. The National Corporations Framework that was achieved in 2001 by the referral of state power is something I appreciate in light of the intractable problems that arise in the governance and regulation of Australian charities in the absence of such a referral of power. So let me conclude by thanking the ALRC and Justice Darrington for reaching out to Melbourne Law School and academics around Australia and inviting us to participate in the special issue. It's been such a great example of how law reformers, academics and stakeholders more broadly can work together to contribute to the improvement of corporations and financial services regulation in Australia. I'll now pass to Justice Darrington to introduce the panel.
Thank you very much, Rosemary. We so much value the contribution that you are making to this inquiry, and we look forward to the conversations around all those very important issues that you've raised continuing over the next 2.5 years. Now, as you all know, we are fortunate to have joining us today 6 contributors to the special issue, each of whom I will briefly introduce. First, we have Scott Donald, an Associate Professor and Director of the Centre for Law, Markets and Regulation at the University of New South Wales. Scott co-authored the article entitled Regulating for Loyalty in the Financial Services Industry with Rosemary and Samuel Walpole. Samuel Walpole is a barrister practising in commercial, regulatory and public law, and prior to joining the bar, he worked as a legal officer at the ALRC, and he is now engaged as a consultant for the ALRC. In addition to working with Rosemary and Scott, Sam co-authored Australia's licensing regimes for financial services, credit and superannuation, 3 tracks towards the Twin Peaks, with Cindy Davies and Gail Pearson. Gail Pearson is a professor with the University of Sydney Business School and is a leading academic in the fields of financial services, commercial and consumer law. Cindy Davies is a legal officer with the ALRC working on our financial services inquiry. Phoebe Tapley is also a legal officer with the ALRC, and she was responsible for co-authoring the article entitled Disclosure Discontent, Regulating Disclosure in Prospectuses and Product Disclosure Statements with Dr. Andrew Godwin. Andrew is now Principal Fellow at Melbourne Law School and Special Counsel and Team Leader for this inquiry at the ALRC. He co-authored the article Legislative Design, Clarifying the Legislative Porridge with Rosemary and Associate Professor Vivian Brand. Now, I will be inviting all of our panellists to reflect on some of the cross-cutting themes from the special issue before we open up the discussion to audience questions for the panel and Rosemary. And I would encourage all of you in the online audience to submit questions and comments via the Zoom Q&A function at any time. We don't expect that we will be able to get to all of your questions, but we will consider every question and comment that comes in the course of the afternoon. Now, the first question I'm going to direct is to Sam and Phoebe. Many of the articles in the special issue highlight challenges associated with the interaction between statutory and other sources of law. In relation to the duties of loyalty, we have statutory duties interacting with analogous general law duties, as discussed in the article co-authored by Sam, Scott and Rosemary's alluded to those already this morning. In the disclosure context, the spectre of delegated legislation looms especially large, and that's made apparent in your article, Phoebe, that you co-wrote with Andrew. So what particular issues do you think this raises, and how might we better manage the interaction between the Corporations Act and other sources of law?
So I think, at least in the sort of loyalty obligation context, what seems to have happened is those statutory obligations that we discuss in the paper, whether that's from life insurance to FOFA, financial advice, all seem to have sort of come out of particular scandals or evolutions in industry or some sort of reactive event. And the ideal of fiduciary loyalty in the general law seems to have been attractive to policymakers as a way of dealing with, as reacting to those scandals. It is attractive, and the prophylactic sort of norm of fiduciary law is attractive, but as always in the law, context is very important, and how these different obligations have then been enacted and how those ideals have been translated into statutory norms differs from the general law. It's not the best interest duty in FOFA is not the same as best interests, you know, in a fiduciary sense or even a company director sense. And that's sort of the real focus of our work was sort of showing the differences in those norms. And I think also the way some of those statutory obligations has been enacted actually doesn't achieve what was perhaps sought, in that the sort of general open textured standard of fiduciary laws then being sort of turned into a checklist in the case of FOFA. And so I think the takeaway for us is that it really, how you enact obligations matters, context matters, and there isn't, just because the same words are used doesn't mean that the obligations are going to be the same. And I think it's just more something that policymakers and legislators need to be aware of going forward, and also that those interpreting legislation need to be aware of in dealing with it.
Phoebe.
So I think in respect of the financial product disclosure requirements, it is particularly the case that the provisions in the Corporations Act are really just the tip of the iceberg. So you have Chapter 60 of the Act, which deals with the preparation of prospectuses for securities. And then Part 7.9 of the Act, dealing primarily with product disclosure statements for other financial products. But then less visible yet equally important is the raft of relevant regulations and schedules to the regulations and the 101 ASIC legislative instruments relating to Chapter 60 and Part 7.9. And while this spread of the law across multiple sources is not unusual in financial services regulation, as Rosemary has already alluded to, I think the role of delegated legislation in the product disclosure space is particularly remarkable in terms of first sheer volume, with Section 1020F in Part 7.9 representing the most cited authority for ASIC legislative instruments, and also in terms of how the delegated legislation interacts with the primary law. So a prime example of the significant role played by delegated legislation in this space is the shorter PDS regime in the corporations regulations, which completely modifies the disclosure requirements for superannuation products, margin loans, and simple managed investment scheme products. And understanding how those requirements interact with the primary law essentially requires the reader to envision or else to manually prepare parallel versions of Part 7.9 with certain provisions omitted, modified, or replaced, depending on which product or circumstances that you're dealing with at that time. So I think the result of these piecemeal modifications across the Act, the regulations, and ASIC instruments is that navigating the product disclosure requirements in Part 7.9 is a bit like a choose your own adventure novel. So if you're required to prepare a PDS, go to 1013C in the Act. But if the PDS relates to a superannuation product, go to Schedule 10D of the regulations. But if the product is solely a pension product, go back to Section 1013C and so forth. So I think in this context, navigability aids like hyperlinks and summary tables would certainly go some way to assisting with how it all fits together. So flagging for the reader which page to flip to, as it were. But ultimately, I think this is an area which calls not just for strategies to manage the existing complexity, but also for reforms to fundamentally reduce that complexity. And that calls, I think, for greater coherence in the structure of the law, what goes where, as Rosemary alluded to, as well as thinking about how we might circumvent the need for these myriad exemptions and modifications to the prescriptive disclosure requirements by, for example, placing greater reliance on a more principles-based obligation of disclosure. Thank you, Judge.
Thanks, Phoebe and Sam. And you've highlighted one of the repetitive themes that we've come across throughout the mapping exercise, and that's the overlap and inconsistencies in the legislative framework. Sam, Scott and Rosemary's article in particular highlights the proliferation of statutory duties of loyalty in a range of contexts. And in relation to licensing, Cindy, Sam and Gail's article raises the possibility of reducing duplication and inconsistencies by consolidating the licensing regimes. So Scott and Cindy, I'll turn to you now. And what do you think is the impact of inconsistencies and overlaps in relation to licensing and duties of loyalty, and how might they be better managed in a rewritten framework?
Okay, well, in examining the licensing regimes for financial services in the Corporations Act, credit in the National Consumer Credit Protection Act, and registrable superannuation entities, or RSEs, in the Superannuation Industry Supervision Act, we started with the purposes of the regimes and then looked at similarities and differences. We considered the AFS and credit licensing both under ASIC regulation with aims of consumer protection and RSE licensing under APRA regulation with aims of prudential safety and financial stability. In terms of inconsistencies and overlaps, many of these entities are regulated by both APRA and ASIC. For example, prior to recent reforms, an RSE licensee authorized an RSE license authorized an RSE to operate a super fund, and then an AFS license was required for an RSE to provide financial product advice or deal in financial products, such as an interest in super funds. Thus, the RSE was regulated both by APRA and ASIC, subject to some exemptions for wholesale clients. As a result of the Financial Sector Reform Hayne Royal Commission Response Act of 2020, this was further detailed. And ASIC was maintained as the chief licensing authority for RC licenses, yet also the Act amended the definition of financial services in the Corporations Act to include a superannuation trustee service, thus requiring all RSCs to hold an AFS license as well. Now, solely being an RSC requires an entity to hold an AFS license. This means that an RSC must meet licensing obligations of both AFS and RSC licensing, 2 sets of conduct obligations, including the duty to act honestly, efficiently, and fairly. There are statutory modifications to minimize overlap. For example, certain AFS obligations don't apply when holding an RSC license. And additionally, ASIC and APRA now co-regulate CIS-Act provisions that have member protection and member outcomes as their touchstone. There's also overlapping regulation where an entity is required to have both an AFS and credit license, say where an entity is engaged in credit activities and provides financial services. The credit licensing regime largely mirrors the AFS licensing regime, both in structure and general licensing obligations. And ASIC itself notes that obligations under both regimes are broadly similar and can generally be met through similar systems and processes. ASIC's powers in relation to granting, suspending, and canceling licenses and considerations it's required to take into account are also very similar. However, while the obligations are very similar, there's also a voluminous amount of separate ASIC regulatory guidance for both AFS and credit licenses. Additionally, there are key differences between the obligations, such as how conflicts are managed. And beyond the general obligations, there are credit-specific obligations and prohibitions, as well as specific rules regarding credit, disclosure obligations, and mortgages. There are also obligations specific to particular types of credit activity. Some have parallels to AFS obligations, while others are unique. There are also provisions that relate only to AFS licenses regarding professional standards and compliance schemes, amongst others. For more granular detail than what I've provided for you here, we've also included a table in our article that compares key obligations of the 3 licensing regimes. So the impact of these overlaps and inconsistencies is a high regulatory burden on licensees seeking to comply with multiple regimes and the associated compliance costs. From the regulator standpoint, there are also costs associated with administering and enforcing the regimes. These impacts raise the question of whether the 3 licensing regimes should be maintained. With regard to AFS and credit licensing, the time may be right to consider integrating, consolidating these regimes, but such further work should consider whether there are any principled and practical impediments to such reform that would impact other regulatory reform mechanisms. And with regard to superannuation, we maintain that superannuation is different from both financial services and credit. It's compulsory, long-term, and favorably taxed. Additionally, the essential trust structure of RSCs and the unique nature of superannuation favor retaining the RSC license. With these final comments then, I'll now turn it over to Scott Donald, who will be discussing duties of loyalty. Thanks, Cindy.
Thank you, Cindy. As Samuel's alluded to, Rosemary, Samuel, and I looked at what literary stylist H.W. Fowler might have termed the elegant variation in the way conflicts of interest are addressed in the regulatory regimes directed towards different sectors of the financial services industry. So politicians and the public have quite rightly railed against transgressive behavior in the financial services industry for much of the past decade. That's resulted in a rash of new rules that attempt to lay down precisely what's expected of market participants in their dealings with their current and prospective customers. Included things like FOFA, stronger super, protecting consumers, member outcomes, the list goes on. We wanted to see if the variations in the way the loyalty aspects of those rules were expressed could be explained by principle. Phrases like best interests and obligations to prioritize customer interests crop up in a number of the regimes, but they appear nestled within a thicket of provisions structured differently, or with different assumptions about how they would be enforced, whether it's private action, regulator action, and so on. Could then the differences be justified by differences in the context in which they were to be applied, by differences in regulatory intensity, or given the sequencing introduction, by simply us learning how to do it better? So we had to consider the possibility that the variations that we could see on the statute could potentially be justified. bit nervous about cutting to the chase because you may choose, of course, not to read the article after this, but what we found was that there were substantive differences between the regimes, and that it would be dangerous for the courts simply to apply their understanding of a term in one area, such as best interest, for instance, in context of managed investment schemes or superannuation funds, to other areas where the same term reappears. There was also a crude spectrum of intensity of loyalty that was expected, from standard directors' duties on one end to mortgage brokers at the other. Superannuation and MIS fund trustees appeared in the middle. Now, this surprised us because we instinctively expected that superannuation fund trustees would have the most intense obligations, given the compulsory nature of super, the requirements of preservation, the fact that many super fund members are not terribly engaged in the institution of which they're enrolled, the impact of the trustee decisions on their future well-being, the opaqueness of the notion of superannuation generally. There were lots of reasons why we thought that actually, from a policy perspective, you would probably expect to see those trustees under more onerous obligations than some others, but that's not quite what we found. Our conclusion was that the political exigencies of responding to successive scandals and the publicity around those had overridden a more principled development of the regulatory regimes in the various contexts. At one level, this isn't surprising, but it does give pause when one thinks about the trend towards purposive statutory interpretation. If the purpose of the legislature is increasingly shrill and urgent, the fabric of our legislative regimes will be stretched and warped, so the substance of semantically similar provisions will potentially differ in ways that are consequential and not necessarily terribly obvious to a first-time reader. I'll perhaps leave it there and let people ask questions if they have them, and pass back to you, Justice Darrington.
Thanks very much for that, Scott. So again, we're seeing this continuing trend of complexity leading to a lack of principle underpinning the legislative provisions, and people being concerned about whether there is justification for the apparent duplication. So Cindy, Sam and Gail's article suggests that the licensing regime for financial services providers and RSEs are sufficiently different to justify separate regulation. But in relation to financial product disclosure, Phoebe and Andrew question whether there is a satisfactory basis for distinguishing between securities and other financial products. So Gail and Andrew, if I can ask you, do you think there's justification for the maintenance of separate regulation with respect to licensing and financial product disclosure?
Thank you, Judge. And thank you to my two collaborators with this article. It's important to bear in mind, I think, that there are all of these licensing regimes are regulating very different products and services with respect to risk. It's also very important to keep in mind with respect to any potential integration of the AFSL and the ACL, that the exclusion of credit from the AFSL was a matter of timing. If you go back to the Wallace recommendations, I think that's really important to remember that. Cindy's already mentioned our magnificent table, so I urge everybody to have who's interested in this to have a very close look at it. So we think that there's a much weaker case to consideration of the integration of the RSC with the AFSL at this point. And I remind everybody that we've been looking primarily at the license obligations, not at disclosure issues. So in part, this is due to the nature of superannuation as a product and its political sensitivity. Superannuation is compulsory. Funds are expected to grow in order to meet retirement objectives. Think the sole purpose test. Funds are also locked up. People can't withdraw them very easily. But contradictorily, an RSE can fail. So, and also, as has also been mentioned, RSEs operate through a trust structure where there should be no conflict between duty and interest. So we've Cindy's already gone through some of the ways in which the RSCs were regulated by APRA and APRA's responsibility under the Superannuation Industry Supervision Act. And it's important, I think, in this context to remember that in the whole of financial services, one's not just talking about the interplay between the Corporations Act and the ASIC Act, but they're all of these product-specific sets of legislation that have to be taken into account as well. So since 2020, as mentioned, RSCs must now also hold an AFSL, and this is not particularly unusual. It's not distinctive of superannuation, think ADIs and insurance. Yet the superannuation regime is distinctive because now both APRA and ASIC are responsible for the covenants in the SIS Act and other prime conduct obligations such as the sole purpose test. This means that both ASIC and APRA are responsible for how RSCs conduct themselves. Think of the regulatory switch from who can be in the market to how people can be in the market. And importantly, ASIC can now enforce these obligations in the interests of individual consumers. But no other product is subject to the long-standing sole purpose test. No other regime must comply with the annual assessments and investment strategies required for my super products. No other regime must undertake APRA's new annual performance tests, and if they fail, tell beneficiaries. No other product is subject to the new, as of 2021, best financial interests tests, that is not just best interests. And this, of course, complements the sole purpose test. ASIC and APRA can and do work well together. And so the new super regime, or the bits of it that are new, need the opportunity to bed down, just as credit did. And a word of caution, if any decision were made to integrate any of these licensing regimes, it's critical, absolutely critical, not to inadvertently lose existing protections for individuals. And it's important in credit not to lose the hard fought for truth in lending obligations in the disclosure laws, the credit disclosure laws. Over to you, Andrew.
Thanks very much, Gail. The question as to whether to maintain separate regimes or consolidate regimes is a question that the ALRC is considering as part of the inquiry. It's relevant to a number of areas, including licensing, as we've just discussed, disclosure, and also the regulation of credit and financial products, as Gail just alluded to. In each case, I think it's necessary to weigh up the benefits of separate regulation against the benefits of consolidation, particularly in terms of achieving greater readability, greater navigability, and ultimately, of course, one would hope, more meaningful compliance. An important point to note, I think, is that many regimes are directed towards the same outcomes, particularly from a consumer or investor protection perspective. This is the case with disclosure, I think. Of course, we need to recognise that the two regimes, namely financial product disclosure in the case of financial products and prospectus disclosure in the case of securities, apply to different activities and arguably involve different objects of protection. So in the case of financial products, we talk about retail clients, whereas in the case of prospectus disclosure and securities, we talk about investors. Both regimes share a general test for disclosure that's directed towards enabling retail clients and investors to make an informed decision. They also share a general standard for information to be presented in a clear, concise, and effective manner. Interestingly, Wallace originally contemplated a single regime for both financial products and securities, but separate regimes were maintained in the Corporations Act following the clerk reforms for reasons, I think, that appeared to have more to do with history and convenience than logic or consistency. So during the course of undertaking the research for our article on disclosure, it became clear that there are certainly some areas of divergence between the two regimes. For example, a prospectus is required to include all the information that investors and their professional advisors would reasonably require to make an informed assessment. By comparison, a PDS, a product disclosure statement, is required to include not just such specified information as a person would reasonably require, it's also required to contain any other information that might reasonably be expected to have a material influence on the decision of a reasonable person whether to acquire the product. So although there's a need to recognise differences in the actual disclosure requirements for different activities, we think that there is a case for an appropriate level of consolidation, particularly in relation to the principles that underpin disclosure and the outcomes that disclosure is intended to achieve. I think disclosure is an area in which a more principles-based, outcomes-focused approach would be beneficial. I think it's also useful to recognise the benefits that technology can provide in terms of tailoring disclosure to the specific needs of retail clients and investors, and the advantages that consolidation and a more unified approach might offer in that regard. Thanks very much, Justice Derrington.
Thank you, Andrew. Rosemary, can I invite you, please, to rejoin the panel? We have a couple of questions from our audience. The first one, I think, Scott, I might ask you to answer this. It comes from Kim Sheehan at Sydney Law School, and she says, recently we've seen a pattern of amendments to corporate law being achieved by way of minimal text in the Act, but a lot of detail in the regs. The advantage, as she correctly observes, is flexibility, but she is concerned that it comes at the expense of detailed scrutiny via specialist parliamentary committees. Her question is, do you see this trend continuing, and do you think it's a positive thing, or should there be a preference for articulating the key points of the law in the primary statute?
Wow, it's a great question. Thank you for that one.
You're welcome to share.
Yes, so I may well enable others to comment as well. Look, it seems to me there's an inconsistent practice here. As I look at the areas that I'm most familiar with, which primarily on wealth management, superannuation, financial advice, those sorts of areas, there are places where the statute is incredibly mind-numbingly detailed, and other areas where it's left very open. And there are areas where there are regulations which are also actually not just detailed, but also very complex to work your way through. And I think actually in some ways that's the bigger problem, is that I've been working with a few colleagues recently on areas where they weren't expert, and actually tracking through all the various interrelated regulations that relate to a particular subject is half the challenge. Finding the ones that matter, working out how they play together, is as difficult as actually reading the regulations in the first place. So I think it's not just simply about where they appear, it's also how they're structured and how easy it is for someone who doesn't spend 12 hours a day, 60 hours a week working through all this stuff. How can they find their way to work out what their obligations or rights might be? And I think that's that becomes a rule of law problem when it's so dense and incomprehensible that someone who's motivated and to try to work out what the law says can't do so. I'm sure others have other comments though as well.
Scott, well, everyone, we're nearly at time, but there is another question that's come through, and Rosemary, perhaps you might address this. The question says, we've seen a shift in government and Treasury rhetoric around areas of corporate law preceding significant amendments. Where do you see the current rhetoric or narrative being currently pitched on financial services law? And do you think there's been a shift in that rhetoric post-Hayne?
That's a very good and complex question. I think there have been several shifts in rhetoric actually since Hayne, would be what I've observed. I think you know, it's a complex question. And one of the other things that I think Scott alluded to is often things happen when there's some sort of scandal or some sort of public outcry, which is another sort of interesting aspect of this. I might actually pass over to Andrew Godwin to answer the rest of that. What do you think, Andrew, in terms of, would you agree with me that there's been a couple of shifts in rhetoric?
I think so. We're constantly, I guess, trying to achieve a balance between prescriptive regulation that helps to protect consumers and also, on the other hand, of course, providing enough flexibility to allow innovation to occur. And we've seen that in the context of credit, and we're seeing it in the context of other regimes that have been introduced. So it's really a constant readjustment of that balance. And I think that's a key issue that we all need to work towards, achieving the right balance in a way that maintains the flexibility that we need, but at the same time doesn't undermine or detract from the consumer protections that are necessary.
Thank you, Andrew. I can see that our participant numbers are starting to drop because we've reached and slightly exceeded the hour. I would encourage all of you who are still with us on the webinar to refer to the CSLJ Special Issue. It can be accessed on the ALRC website. Thomson Reuters has very kindly made the PDFs available for us on our website, but they're only able to be downloaded until Monday of next week. That's Monday, the 26th of July. I'd also invite all of you who have participated to visit the ALRC website for further information on the inquiry and to subscribe to our mailing list for updates. We will continue, of course, to post inquiry updates on social media such as LinkedIn and Twitter, and we will continue with these types of webinars and one day in-person seminars around the country once we've all been vaccinated, I suspect. So I'd like to thank all of you. We had, I think, at its peak, 210 people watching online at the beginning. Thank you all very much for joining us. And sincere thanks to all of the speakers and panellists, and particularly Melbourne Law School for facilitating the event. We look forward to this ongoing conversation over the next 2.5 years. Thank you, everyone.